They're reducing or limiting the requirement for physicians to be licensed in a particular state to do the work, but that doesn't mean you can go to the state. I think there's some particular problems with that.
No, that would still be a false claim. You're still excluded.
They don't give a time frame, but I don't want people to think they can last forever. Good afternoon, everybody, and thank you so much for joining into Chapman Law Group Healthcare Hot Topics. I know with the coronavirus scare going around and certain restrictions and things that are happening, I know that a lot of our practitioner clients are being overwhelmed with patients, with concerns, with questions, and you might not have the answers. So we put together a pretty substantial roundtable to try and discuss some of them. We have Ron Chapman II, who heads our criminal division, and also has an LLM from Loyola in healthcare law. We have Aaron Kemp, who heads our regulatory division. Regulatory covers licensing, credentialing, peer review, all of those types of things. And then we have Andre Parada, who is also in our compliance, has spent many years in compliance. And my name is Ron Chapman. I also have an LLM from Loyola and have spent 35 years in healthcare. So welcome, gentlemen.
Welcome. Welcome. Hello.
I think one of the concerns that we want to talk about today is there was this emergency declaration by the president. I know that CMS has issued a number of guideline changes. So why don't we talk about those? And I also know from personal experience, my daughter owns a healthcare clinic, and there were a lot of concerns about who to test, who not to test, hospitals turning people away, not testing them, those types of things. So opening it up to some comments, and let's just generally talk about issues that might relate to practitioners.
Well, I think first and foremost, we have EMTALA out there, which sets certain conditions on hospitals and requires them to treat patients when they arrive at the hospital to some extent. And I think it's going to be very interesting to see how the government navigates the requirements of EMTALA with a corresponding fill in critical care bed space that I think the government is anticipating at this point in time. Does anybody have any thoughts on how the government may maneuver around that, or what hospitals and providers can do when faced with EMTALA in this situation?
Well, I think when faced with EMTALA, they simply can't turn anybody away that's in an emergent condition. That question will be severely tested when bed space fills up and you have no space, which is one of the exceptions to EMTALA. But then you have to find another place to send them. And we'll have to see. I mean, one of the differences here than maybe in Italy. One of our associates has family in Italy and is from Italy, and she was telling me this morning that one of the major problems is they're running out of ventilators or they're running out of bed space and things. But Italy's a smaller country with probably less medical capacity than we have. So this will be a good test of our capacity to handle those critical care. When it comes to practitioners, of course, EMTALA doesn't apply to urgent cares and family practice centers. And I think they're potentially being overrun, at least with demands for testing.
Along that same token, Ron, in the aspect, not necessarily an emergency medicine avenue, but a primary care, the burdens that primary care providers that you initially discussed are under. Part of the emergency declaration was some of the lessening of the restrictions on telemedicine and telehealth. A particular interest is for the older population who feels potentially that they want to get tested, but they don't want to go into their clinic or their primary care provider's office because of the risk of potentially contracting the virus. So CMS luckily has, at least my understanding so far of the emergency declaration, has loosened some of the restrictions on telehealth medicine. One of the important factors in reading some of the loosening of the strings, so to speak, is that the physician had to have had in the past 3 years a previous incident, a previous E&M service effectively with that same patient in order for this to qualify for reimbursement for the provider. Previously, if the restrictions had been currently in place without the emergency declaration, telehealth medicine and reimbursement under Medicare is fairly limited. It applies specifically to instances where the patient has to go to a facility that's located, for example, in a rural health clinic. That requirement has now been waived. But there are other restrictions, mainly the physician had to have had an E&M visit with a particular patient over the last 3 years. But there's another specific wrinkle where a new Medicare patient is the way I read it and the way I've understood it so far, that they are not eligible for this telehealth benefit, at least with regard to the physician performing a telehealth episode and then seeking reimbursement from Medicare. I bring that up because obviously this is appearing to affect older populations, but to this example, say someone just got on Medicare this year, they were 64 last year, now 65, Medicare eligible. Those new Medicare patients, to me, are still not under this, they don't fall under this waiver. But certainly, I do feel that this is just the beginning, though, because telehealth is going to be of critical importance for people who want to contact their primary care provider, address any specific symptoms they may feel or they feel that are being approaching to them. And it's a way for them to keep their safe distance, but also receiving the medical care that they need. But also from the provider's perspective, our clients, we want to ensure that they're getting paid and reimbursed for those services that are being rendered. So some strings have been loosened. I would anticipate some additional waivers to be granted to really ramp up the telehealth capacity for both providers and patients who are seeking services.
I think it's important for our viewers to also know that the federal government can waive for Medicare, Medicaid, other government services, TRICARE, CHIPS, things like that, but they can't waive for traditional state requirements. In most states, for example, Florida, and this bothers me a great deal with telehealth because I think while it's the wave of the future, I think there's huge problems now. Like Florida and Michigan, for example, you still have to comply with the standard of care. So I'm wondering when a patient calls and says, hey, I think I might have the coronavirus, I'm a little short of breath, what are you going to do? You can't auscultate the person's chest. You can't take a blood pressure. So I don't know what kind of service you can provide. And I think this also leaves, and maybe Ron, you could address this, a huge opportunity for scammers to start coming in, opening up these very quick telehealth, and you're really not getting telehealth. And maybe you're being placed on a false belief that you're okay when maybe you're not.
So I know the scammers will start coming out of the woodwork here. I think from a practical standpoint for physicians and providers, telehealth can be a valuable tool to monitor symptoms of those people infected with the coronavirus who don't require emergency treatment, and to make the call to determine whether or not they may be a candidate based on their symptoms for at least an office visit checkup. So it'll be a nice gateway to treatment to ensure that people's symptoms are being monitored. But then from the scam artist perspective, I'm sure that we're going to start seeing instances where people are taking advantage of some of the waivers and rule changes that are in place for financial gain. I'm sure that we're probably going to see some fake testing out there. We may even see some clinics overbilling for treatment because the federal government's going to be backlogged on these types of claims and probably approve, all of the claims and let them go through. I think we'll be sorting out a lot of fraud for the next maybe year or a few years to come based on coronavirus. So the important thing to remember from the fraud standpoint, the anti-fraud standpoint, is document, document, document. If you're testing coronavirus more than all of your peers and you have a South Florida clinic, rest assured that at some point government investigators may start looking at the reason why you had hundreds or thousands more tests than your peers, and they may target you for an investigation. And without proper documentation of the medical necessity for the treatment and the testing, you may be a candidate for at least a recoupment or potentially fraud allegations.
Ron, you raised a good point there for follow-up treatment. And Andre, maybe you can comment on this as well. And that is, so you've seen a patient has, coronavirus. They're not extreme. They go home to basically self-quarantine. And now you want to check up on them every 2 days or so and talk to them to find out how their symptoms. I'm wondering if that would be appropriately billed as a 99212, and if you could get away with it even though there's not an office visit, particularly since office visits would be, seriously frowned upon if you have a COVID-19 tested positive patient coming in and sitting in the waiting room with others that may not have COVID-19?
Yeah, it's a great question. I'm not sure if there's a definitive answer at this point regarding potentially billing for those subsequent call-ups and as an E&M service, because of the very fact that you mentioned, Ron, it requires an in-office visit, and this is being done remotely via telecommunications. But certainly to Ron's second point about documentation, it's going to become critical. It already is, of course, under normal circumstances, but under these circumstances, of course, it's going to become critical to document everything that's being done. So to your specific question, Ron, about whether the post after initial consultation via telehealth, if subsequent follow-ups can be billed, I would recommend contacting your health law attorney to navigate those uncharted waters. But certainly they're over document. If any provider is worried about potentially billing and seeking reimbursement for this, over document and meticulously document the services that they are providing. But as far as billing those E&M services via the follow-up calls, I think at this point it would be premature to advise anybody that they can do so.
Well, that's true, but I also think that we have practitioners who are going to spend a lot of time on the phone talking to people.
Yep.
So I think some good advice, and correct me if I'm wrong, gentlemen, if you think I'm incorrect, is that you document that just like an office visit. You try to address the review of systems you can, even if it's just communicating to them. Are you still short of breath? Do you have a sore throat? These types of things. And then, document the medical decision-making that you have to make. And they could be, take more fluids, do this, take some over-the-counter pain medication, all of those kinds of things. And then accumulate that. And then maybe we can bill it and we'll see. One of the things the government did for labs is they created a brand new COVID-19 billing. So they now bill under U22 or U0002. They did the same thing for SARS a while back, and that was U001, and they'll get immediate reimbursement. So I think there will have to be, and maybe we can be a significant voice for those practitioners and lobby for them if they keep the documentation and document the medical necessity. Because I suspect they certainly should be paid by private carriers and government carriers.
I would agree with that. I agree with everything that you said, and I like to everybody's point that we're making is that documentation is going to be critical, because to your son's point, in the event that you're treating and billing for services related to coronavirus treatment or assessments, and you're way above the mean, so to speak, compared to your competitors, there will be an audit at some point, and so the documentation becomes critical as it is in any circumstance.
I think one of the points being raised is when there's an emergency, that doesn't mean you can throw everything you learned out the window. You still have to have medical necessity. You still have to have proper examinations. It's just that some of the things I'm sure will be loosened. And one of those things, I know under the CMS guidelines, they waived the requirement that you be licensed in the state that you provide Medicare and Medicaid services. And any of us can address that. I think one of the problems might be, though, licensing of physicians is a state function, not a federal function. So while they might be able to say that, I'm not so sure they could allow an Ohio physician to walk into Michigan or a Georgia physician to walk into Florida.
It's probably an attractive proposition for a physician who's licensed in multiple states to have the ability to not only expand from the state where his primary practice is to an adjoining state perhaps and offer immediate Medicare care, but it doesn't mean that someone who isn't licensed in that state can expect to walk in that state, obtain Medicare providership, and then expect to perform care without being properly licensed. Now, states may provide waivers, very shortly to encourage medical care, but none of that's happened so far, at least here in Michigan. I'm sure not in Florida.
When I was looking over go ahead, Ron.
Aaron, do you think that the emergency declaration and the CMS waivers are going to be a signal to those states to start freeing up licensure requirements? Do you expect that on the horizon?
I expect that, absolutely. It seems like they're lagging a bit behind CMS. The governor here in Michigan, she signed a declaration expanding telehealth access last week. However, we haven't seen any regulations or any emergency declaration like CMS. So I think that's on the horizon very shortly, but they're just lagging behind.
Okay.
And I know, for example, some states, very strongly, some more than others, regulate the practice within their own states. And I suspect you have a lot of doctors vacationing in Florida. I don't think all of a sudden they can start practicing medicine in Florida on the private population. They may be able to get a waiver for Medicare, Medicaid, but correct me if I'm wrong, gentlemen, but I don't see a shortage of healthcare providers. I'm not hearing that in the news. I did some searching today. I'm not seeing where there's a shortage of access to care. I see the concern there may be an access problem to ventilators in acute care and ICU type care, but I don't know, with urgent cares and other things that are coming around, I'm not sure about that. Have any of you seen anything relating to that?
Well, we're hearing a lot of reports, and I think a lot of this stemmed from news that was coming from Italy that the healthcare providers were being overworked. I've had the opportunity to speak with a number of healthcare providers in Michigan and in other states since that news broke out to see what they're doing. And we are seeing our hospitals, local hospitals, lean forward and try to do things to mitigate this potential overflow issue by creating more bed space. So I think that's causing a bit of a drain on the current healthcare environment. You have people who need to take care of sick patients already because hospitals typically don't overstaff. In fact, they routinely understaff with this added drain of the additional coronavirus patients and work that's required to be done before we get a large number of patients filtering into these hospitals. So I don't know that we'll have a shortage of doctors. I actually think that the issue will be a shortage of mid-levels, a shortage of nurses in nursing homes, a shortage of certified nursing assistants, and other non-physician employees to be able to help. Because, the practical issue is at play when we have many of the nation's parents having to stay home and watch kids because they're out of school. Who's going to go and staff some of those positions? And I think that's going to be very complicated for us. So I guess to answer your question, Ron, I think maybe not as much of a shortage of physicians, but we really should be worried about a shortage of the additional type of medical services that we require.
Let me throw out another question. Can a healthcare provider, if they're concerned, refuse to treat patients that they feel might have COVID-19? Let's say they're a little concerned and they don't want to open their clinic to that type of thing. I've heard of people doing that. What do you think?
You get into some regulatory compliance issues too. If you're a Medicare enrolled provider and turning away patients, for example, if they're Medicare beneficiaries, you get into some compliance or regulatory issues there about not, having the blanket requirement to accept Medicare patients. That doesn't necessarily mean that you have to accept every single one who walks into your door. You can make an argument essentially that on a case-by-case basis, yes, but the whole point of being a medical provider is to treat people who need medical care. And so if you're concerned that the exposure you're going to get from COVID-19 in your medical provider, perhaps you've entered the wrong line of work. I mean, that defeats the purpose of being a provider. Certainly the worries are valid and concerned, but I think protective measures need to be in place for those types of providers. And you do get into, at least from a Medicare perspective, considering the types of patients who are typically seen for this particular virus, if you're choosing not to treat them, you run the risk of running afoul of very serious Medicare regulations, especially if you're an enrolled Medicare provider.
Which kind of brings up another question. What should our, owners of our clinics do for their employees? What type of protective equipment should be required of them? I don't think they can walk around all day in, zombie suits, so to speak, with, big hood masks and ventilators and things, but certainly something ought to happen. This is a little different than the flu virus.
Right. Yeah. Well, I think that one thing that can be done, and this may be a bit more of a medical question than a legal question, is we're seeing the use of drive-through clinics and testing facilities. I think the biggest need right now is to make sure that we can take care of that potential 20% that need hospitalization, and the rest just get them tested. So for the regular doctor's office, I'm not so sure there's as much of a need to have patients sitting down in the office being examined by a medical provider. I think that drive-through tests and maybe telehealth can take care of that patient population without in-office visits. And those people that require more urgent or emergent type care can go directly to the hospital. But maybe there is a middle of the road sickness that may require examination by a PCP. I just don't think we've seen that yet.
One of the other issues that CMS raised, or one of the waivers, is for provider enrollment. They said specifically that application fees, criminal background checks, site visits, all of which will be waived for physicians and non-physician practitioners that want to enroll in Medicare, in CMS, Medicare, Medicaid. What types of advice will we give them? Because I think certainly if you've been excluded, if you have, a felony or some other kind of excluded thing, even though you might get it by now, what if you do that and then later on it's found out? What about all the claims you're filing now? I think they might be false claims.
There's a potential for a False Claim Act violation. Certainly, we are, without revealing client count, we have certain clients in those positions, so to speak, that are under an enrollment bar, let's say, for Medicare. We are certainly currently seeking waivers with regard to their ability to treat Medicare patients, but the waiver would apply specifically to billing Medicare for these treatments only. So in other words, it's not carte blanche, so to speak. You get a waiver and you can start treating Medicare patients for other conditions and other ailments unrelated to the COVID-19, which is the genesis, of course, of this whole emergency declaration and these subsequent waivers that are being issued. But it's certainly an option to explore, of course, because back to your original question of the potential shortage, and I agree with what everyone has said. I don't think necessarily we're seeing a shortage of providers. Of course, the space and the equipment is the greater concern. The governor of New York, I think, is asking the Army Corps of Engineers to build these makeshift hospitals, like I think they did in China. But back to the original point of excluded providers, obviously everything here is uncharted waters, but certainly that is an option we are pursuing for some of our clients regarding waivers. For clients that are not disbarred or under an enrollment bar or excluded for purposes of like patient neglect or abuse or a fraudulent scheme. If they had another criminal matter that's totally unrelated to their ability to practice or their treatment of individuals, certainly that's an avenue to explore. And I think CMS would be open to that. Of course, I think they're going to adjudicate those on a case-by-case basis, whether or not to grant waivers.
So with the advice we give then is that any practitioners that of our clients or potential clients, that they should call us or some other competent healthcare providers. Of course, we prefer that they call us, and then we would walk them through that waiver, because
Right.
I think getting a waiver when you're not entitled to a waiver sets you up for some pretty serious prosecution. And my belief is when this is all over, 2 months from now, 2 weeks from now, 6 months from now, whatever, I suspect there will be a lot of prosecutions, because bad things like this, when money starts flowing very easily, people start figuring out ways to tap into that and get some of that money.
Yeah, and the False Claims Act was created because of the Civil War and contractors taking advantage of the state the country was in at that time. And I think that that's one of the first things that the federal government will look at. And I'm sure that we will see investigations and likely prosecutions. So it's important for everybody to see these waivers and this opening up of the regulatory system as not something to be taken advantage of, but an area to tread very carefully on. Because if you run afoul of even these waivers, you could be hit with some sort of scrutiny from the federal government. While it may just be an audit, it very well could be a federal investigation, which is our concern.
And many of the waivers that came down, it's not necessarily our specialty within healthcare, but came down for acute bed hospitals, psychiatric facilities, nursing homes had some significant waivers, one of which is basically lockdown, and the other was allowing them to, I guess, perform other types of procedures in their setting that otherwise they wouldn't be able to. Anybody have any other comments that they'd like to make? I know this is a little brief, and maybe we'll do these every couple days to let people know some things. It's kind of a moving target, and we don't always know where it's going. Courts are starting to close down. I know, Ron, you work a lot in white-collar physicians that are charged with false claims, overprescribing opioids, those types of things. What are the courts doing these days?
Well, so we're seeing a smattering of resolutions from the districts. We've noticed in Kentucky, they were the first to act. Kentucky suspended all hearings for 30 days. We've seen something come out of the Eastern District of Michigan that was very similar. I had a conversation with a federal judge not too long ago who indicated that the circuits were meeting in order to find a resolution. I imagine the circuit Supreme Court judges, there's a justice assigned to every circuit of the Supreme Court. That they are going to be making the call for their circuits as to what to do with current federal cases. That being said, from a more practical standpoint, I have a feeling that jury trials will likely not go for the foreseeable future, because getting 75 to 100 people together in a jury pool could be a very serious danger. So I would expect to see suspension of jury trials soon. Ron, you saw that in Florida, where the Supreme Court suspended all jury trials for a certain period of time. And I think that we'll see the same thing. The wheels of justice won't halt. I think they're going to take a pause. And then when the peak starts to clear, that will be one of the first things that needs to be resumed, because it is a constitutional requirement.
I did see, on a good note, Andre helps us with this, and we have other people on our staff that do. We do a lot of CMS appeals for overpayments, et cetera. And they did indicate in part of CMS recent emergency guidelines that they are extending the file dates for appeals, for responses. But I don't believe, and Andre, correct me if you feel differently, I don't think there's carte blanche for our providers just to disregard those dates. I think they still need to get to counsel as fast as they can, but I think in many respects, those dates can be extended. And if you've missed a deadline, I think you just need to get to your counsel, and I would bet there's a very, very strong probability that that deadline would be extended under these extenuating circumstances. I think a lot of our providers have more important things to do treating their population than gathering records and making sure that Medicare has all the things, but I don't think they should stop. What do you think, Andre?
Yeah, correct. I mean, I would still operate under the assumption that the deadlines indicated in your notification letters from CMS are still in effect. I think there has been, I'm not sure the date, whether it's been extended by 30 or 60, potentially even 90 days. We are currently working with clients that are under investigation, and we're complying with all the deadlines made, but CMS understands the situation and is willing to work with them. To your point, that obviously takes valuable resources and time by the providers, mid-level providers, and even staff to compile these records, to send them out. So if you work with CMS, consult your legal counsel and work with CMS, because they have been very workable in terms of extending these deadlines regarding those types of appeals. But certainly we're still operating, unless directly told otherwise, that the timelines indicated on your notification letters from CMS are still in effect, unless specifically notified to the contrary.
Anybody else have anything that they would like to add?
Just
Well, I think,
just
go
a
ahead,
final
Ron.
thought. I'm sure that the next few months are going to be trying for the healthcare system in general. And I just, for those healthcare professionals that are watching this, just want to say thank you for all that you've already done, and for the tough times that you're about to go through and experiencing this virus, the impacts of it, and sacrificing time away from your family and loved ones in order to help people you don't know. It oftentimes is a thankless service, and I just want to say thank you to all healthcare providers out there, and to let you know that whatever you need from us, we'll be here. We're a phone call away to help answer your questions, to help work through some of these compliance issues and make sure that you stay on the right side of the law.
That's exactly right.
Thank you, Ron. Go ahead, Andre.
I echo those comments. I mean, the healthcare providers, from the physicians to the mid-level providers we discussed earlier, to the nurses, everybody's on the front lines, and kudos to them. You guys are doing this battle. And to Ron's point as well, let us handle any of the regulatory compliance and other legal issues you guys are certainly going to be under during these times. We'll handle that to relieve that stress that you guys are always under. But certainly, you guys are heroes in fighting on the front lines. So we can't thank you enough.
Well, thank you, everybody. And to echo what everybody else has said, that Chapman Law Group is here to help. We have 17 attorneys that are highly skilled in healthcare. That's all that we do. And we're here to help you. Call any one of the people here. You can call Aaron Kemp, who's in charge of our regulatory, or any member of his team. Andre, who one of the lead attorneys in our compliance. Ron, who is in charge of our white collar, or myself for civil litigation or compliance related matters. We're here to help you. We'll be keeping you abreast as things happen. We know it's happening very quickly. But I'd like to thank, gentlemen, all of you, Ron, Aaron, and Andre, for taking the time to be here with us today. And I'm sure we'll get back to everybody in the next 48 hours and see what happens. Be safe and take care.